Hi, my name is Raj Sharma. I'm the managing partner of Stewart Sharma Harshani, one of Canada's largest dedicated immigration law firms. Today I'll be talking about Bill C24, the so-called Strengthening Canadian Citizenship Act. Bill C24 has received royal assent. Canadian citizenship is now harder to get and easier to lose. Transforming Canadian citizenship was perhaps the last to-do on Jason Kenney's list of immigration changes. Jason Kenney has now remade Citizenship and Immigration Canada to better reflect the values of his government, which in all fairness, he has the electoral mandate to do so. Bill C24 increases the residency requirement to 4 years out of 6, with a minimum of 180 days of physical residency in each of the 4 consecutive years. Bill C24 requires applicants to state their intent of residing in Canada at the time of the application. Bill C24 makes it easier for the government to revoke your citizenship. And finally, Bill C24 requires applicants to provide proof of language proficiency between the ages of 14 and 64 years of age. I'm going to talk about the increased residency requirement, which in my opinion, is the most defensible part of this bill. Some of the changes in Bill C24 simply don't make any sense. For example, Bill C24 eliminates consideration of any time spent in Canada prior to becoming a permanent resident. That means someone that comes, for example, as a student and then works in Canada and then becomes a permanent resident could be in this country for years before being able to apply for Canadian citizenship. That doesn't seem to make any sense, nor is there any rationale behind eliminating consideration of any time prior to becoming a permanent resident. Bill C24 was apparently enacted to combat the problem of Canadians of convenience. There are individuals that come to Canada simply to obtain the Canadian passport, which allows visa-free travel to over 150 countries. Some spend the requisite time in Canada. Some of my clients even call it immigration jail. And they spend their time in Canada and then they get their passport and then they leave. Hong Kong apparently is one of the largest cities with Canadian citizens. There's hundreds of thousands of Canadian citizens living in Hong Kong right now with little or no ties to this country. Other individuals commit residency fraud. They exaggerate or embellish their time in Canada to get that Canadian passport. Justice Anne McTavish of the federal court recently fined a family more than $60,000 for claiming that they were in Canada when in fact they were living, working, and studying in the Middle East. Finally, the fact of the matter is that under the old Act, people were getting citizenship in Canada while spending very few days in Canada. The problem is that the old Act didn't define residency. And Justice Anise commented on this matter in a recent federal court decision where a citizenship judge granted citizenship to someone that had only spent 160 days in Canada in the previous 4 years to the application. I agree with the minister and most of the judgments from the federal court. There's only one way to become a Canadian, and that's to spend a lot of time here. Prior to 1977, an applicant for Canadian citizenship had to be in Canada for 5 years. If you look at other countries around the globe, such as the US and the UK, they also have far more stringent residency requirements. The problem with the old test, like I said, was that there was no actual definition of the residency requirement. And so 2 or 3 tests developed at the federal court. One required 2 feet on the ground for 3 years out of 4, and the others didn't. We can call them a subjective test and an objective test. In any event, the federal court itself was frustrated and called for legislative intervention, and the Conservatives have now delivered. So, in conclusion, this government or any other government has the mandate to require applicants for Canadian citizenship to spend more time in Canada. There was also an apparent problem of so-called Canadians of convenience. Finally, the federal court itself lamented the state of affairs in terms of the subjective test under the old Act. The Conservative government has delivered. Bill C24 now brings order to chaos and far more objectivity. As a result of Bill C24's, it will be harder to get citizenship. Many professionals are required to travel extensively outside Canada. This is not their fault, and they will be denied Canadian citizenship until such time as their circumstances permit them to spend the requisite period of time in Canada. Students that choose to study abroad may also be adversely or negatively affected by these changes. But there's transnational professionals and students that live in the US and the UK as well. There is a modicum of discretion under the Act to deal with deserving cases, individuals that can't meet the residency requirement for whatever reason. Subsection 5, sub 4 still allows the minister to grant citizenship to deserving cases. Bottom line, other than a lack of credit for time spent in Canada prior to becoming a permanent resident, there's little to disagree with the increase in the residency requirement under Bill C24. Those are my thoughts on Bill C24, strengthening Canadian citizenship. If you have questions regarding citizenship or any other immigration matter, please feel free to contact one of the lawyers at Raj Sharma. We look forward to assisting you.